All right, please invite the officials to join us.
我哋係得3個議員嘅啫，呢一個委員會。
唔好意思啊，兩位議員，因為咧我其實
Sorry, gentlemen. I want to talk about third-party rights. I need to clarify something with the administration.
就告你，你唔去打都冇事喎，係咪？
一陣間詳細講一講。好。好，我唔再次介紹。
All right, I'm not going to introduce the officials by name. This is already the second meeting. We have received CV1 215/1314 bracket 02. That's the paper number. So, members, do you have further questions to raise? Because I have a question for the administration. It's about paragraph 9. I asked the administration to explain the third-party rights, and that is if the ILD has an agreement or has a request from another authority in asking for information of a data subject, and you ask another person in the jurisdiction to hand over certain information. I'm concerned about that the requested party would receive just a letter from the ILD for the information, and I've given some examples. For example, say if the requesting jurisdiction is the U.S., whether it's under common law or the Constitution, there's some provision against self-incrimination. And if I'm asking for information, tax information of a certain person, and if I disclose this to you and you pass it on to the U.S., and as a result, I will be prosecuted for murder, for crime, or whatever in the U.S. You ask the question on behalf of the U.S. authority. So would you be willing to give me information sufficient for me to fight my case in the U.S.? If I win, the U.S. authority will not ask you to get the information for them. Now you're saying that the first hurdle is that the data subject must agree, and then the relevant overseas authority would also have to agree. And you don't forget that I'm handing over information to you in relation to my friend's information. That's by way of example, so that you understand that a third party may need to do something to safeguard his right. But if you need the consent of every party concerned, then there's no way that third party can do this. Last time when this was discussed, not all members were present. So perhaps the administration should explain further paragraph 9 before we proceed to a discussion. Maybe I should also say something about the other paragraphs by way of background information. In Hong Kong, if we sign a CDTA with a tax overseas jurisdiction, then we have this obligation to hand over information. When a request is received and the information is not with the ILD, of course, the ILD will send a notice to the related parties to get the information. It can be the data subject or maybe some other third party who are not subject to any investigation. So therefore, in the case of a third party, the ILD will, in issuing the notice, provide relevant information so that the information holder can find the relevant information, collate the information, and then give it to the ILD. You asked last time on the criteria in doing this. In paragraphs 7 and 8, we set out our response. That is to say, in relation to information exchange between the jurisdictions, they will be acting in accordance with Article 26 of the OECD Model Tax Convention. And the exchange of information should be treated as confidential or secret and should only be disclosed to persons or authorities concerned with the assessment or collection of tax. So they cannot get the information and use it for other criminal investigation or criminal prosecution. And only those who are related in the enforcement of such tax matters can have access to information. So paragraph 7 talk about the confidentiality and the requesting or the letter of the requesting authority is also subject to the confidentiality requirement. Of course, when you ask another one to identify certain information, you must give certain information to the information holder so that this can be done. So as a matter of fact, the ILD would provide some basic information to the information holder to facilitate compliance. We have reviewed the current mode of operation in the light of comments made last time. We have to make sure that the exchange of information mechanism is effective, international criteria and standards, because this has to do with the expectation of our counterparties, and there's a need to strike a balance. The information holder may not be the subject. So shouldn't the subject be allowed to know? We need to find a balance, and that's what we have set out in paragraph 9. If the relevant parties concerned are agreeable, this can be done. Although in the past, no information holder has made such a request concerning the identity of the requesting party. If there's such a request, then ILD will act in accordance with what's set out in paragraph 9, and that is with the consent of the relevant parties, we can relay the information, the request, to the requesting jurisdiction. So we have we need to strike a balance. I need to cut you short. Paragraph 8 is about the standard of minimum information to be provided. Well, this is subject to negotiation. Can you tell us which country or countries are involved? If I'm a businessman, you ask me for information of my legal advisor, tax information, something between us. You said no information about crimes will be involved. That's not true. Maybe he has given me some information concerning the fact that she has committed murder. Well, that's dramatic, but it can be fraud, it can be tax evasion, or a joint tax evasion operation. And you don't forget, I'm not supposed to incriminate myself. So you should at least tell me that it's from the U.S., Italy, or other jurisdictions, so that I can ascertain whether I have been involved in such matters, or I may want to take legal action in that jurisdiction, or I can give you a reasonable excuse. I can tell you that I have taken legal action. So to cut short the whole matter, can you tell us who the requesting authority or jurisdiction is? Well, the request is made because they are investigating a subject person. So how much information should be disclosed depends on the actual need. Well, the subject person will know from which jurisdiction the request is made. Well, but the requesting authority is now my enemy, and we are not on the same side. Mrs. Guan, please think about this if you are not clear about this. Or Mr. Chiu, it's very simple. Don't waste our time. You know what I'm asking for? I just want to know which jurisdiction it is. Concerning the point about self-incrimination. And our CDTA is modeled on the OECD Tax Convention, where you can find detailed explanation. And there's something on self-incrimination. In gathering information, if someone claims self-incrimination as a defense, it's acceptable. But of course, the information holder must show that there's such a risk of self-incrimination before this can be put up as a defense. If the ILD then certified this is to be the case, then the information concerned may not be handed over to the requesting jurisdiction. That's not very useful. If I don't know which jurisdiction it is, I cannot really give you good solid grounds that such information may involve self-incrimination. It may be self-incrimination in respect of Italy, but not the U.S. But this time the request is from the U.S. and not from Italy, because I have to prove this. I have to show this to you, and you need to make a judgment. If you are not doing this in a reasonable manner, I can launch a judicial review. Under the OECD Convention, self-incrimination means that the defense is raised by the subject person. It's not applicable to a bank and so on and so forth. I'm not talking about a bank. Well, I'm repeating the OECD definition. I know, but I'm talking about something deeper. Please consider this. Only the country name is required. We have certain international conventions, and we want to adhere to that. Are we under any contractual obligation not to disclose the name of the country? Are we going to violate our obligations in any way if the information is provided? Chairman, when it comes to international standard, as we have said, you can say that it may not be a prohibition or violation as such. If not, then if it's a violation, we will not be able to provide the fine-tuning arrangement in paragraph 9. Well, if everyone agrees, of course it can be done. If the requesting jurisdiction agrees, how can you not to agree? This is necessarily true by implication. I'm not talking about this page 9. If we do what I want, i.e. disclosing the name of the country, would it be a violation of any convention? Let me try another approach. You have signed 21 CDTAs. Which CDTA are you invoking? Then I will know the requesting jurisdiction is involved. Tell me which CDTA is involved. 5 A, B, C, D to F. You can add G. You will tell the information holder that you are acting in accordance of a certain CDTA, and then the other party would know. We believe there must be a reasonable process before we act like this. Then you are not listening to our grounds and Mr. Sins. Well, we understand that members would like to know which country is making the request. We understand that. So, Ms. Guan, you are not going to consider this. Is that the answer? We have already considered this. Yes, you did. Last time you said you would consider this. I want you to reconsider this to see if for paragraph 5, A to F, in the notification, you tell the party that you are doing this pursuant to a particular CDTA. You have more than 30 CDTAs. This is the legal basis for making a request. Well, maybe I can give you an example to illustrate the point. Say if ILD, Hong Kong ILD, is investigating a case, and we make a request to the UK authority, asking for information, and the UK authority approaches a bank in the UK for the information. Should the UK authority tells the English bank that now Hong Kong SAR government is investigating a case? I think it's just fair. Because implementation of CDTA is reciprocal. If the UK authority discloses the fact that its request is from Hong Kong, it may affect the ILD's investigation, because the subject would have known we have received the information now that the Hong Kong ILD is doing the investigation.
Why is that a problem? You have to have a balance. The balance, yes, is okay. So they know that Hong Kong is investigating them, but in my example, that information holder should have a way to protect itself. Now, let's say if the bank, they don't have to face a big problem, so we don't have to talk about banks at all. But if the information holder is a private individual or a private company, that is a very serious. So if I know who the country is, then perhaps I can go to that country and fight the disclosure. I can't just say that, yes, I'm actually evading tax in 100 countries. And then I would incriminate myself as well as the subject, the information subject. Can you think of a way to have a more detailed and in-depth balance? No. I'm not saying that you have to provide every letter under 5. But if the information holder asks for this, can you tell him this information? I think that's very reasonable. If that person already said the ground for self-incrimination, that means he has a valid ground under OECD. So do you think that's reasonable to be so detailed? I really hope the administration, Ms. Kwan, now you understand that when we're thinking about this, we have to find a balance. If for everything you're only thinking about your own side or your own way of thinking, that is not fair. Now, this is a right about the person who's paying tax. Now, this right may be infringed by other parties under this, so you should give them a protection so that they can fight for this. Yes, of course, I agree that there must be a balance between rights and enforcement of the law, but in the end, we believe that, as I've said before about how much information should be disclosed, it really depends on the actual situation. Why is it the information subject has a right to know who is requesting for the information? It's because this request is about this particular individual. Now, you must... Yes, okay, you're investigating, let's say, the legal consultant, for an example. Let's say the U.S. wants to know his information. But you asked me for information about him. Now, perhaps I transfer some money to him. Yes, I understand. Yes, because he is the information subject. So the difference, it really depends on the actual information. Yes, of course, the information subject, of course, knows. But perhaps as information holder, I may have an implication under the law of that particular jurisdiction. So if the information is about the information subject of the information holder, and then they investigate the information holder, of course. No, you don't understand. Now, if you tell me as the information holder that Italy wants to have that information, I will go to Italy and fight my case. Now, Italy's searching someone else. If they don't want information from me anymore, they don't ask me. Do you understand? Yes, I understand. I just want to show that the difference between the two. Yes, of course it's a difference, but you need to protect other people. Now, if me as an information holder, my company is bankrupted because of this. You have to think about me. I believe that when RRD gets the request, the actual situation is that someone... Now, Ms. Kwan, if you think that you will not consider this, perhaps let's give another meeting, and I'll ask the secretary to come. Secretary or the financial secretary. I want him to hear this. Sorry. I don't think my question has been answered. Is it a violation of the agreement? Can you be a little bit more concrete? Which article is it infringing, Chairman? As I've explained before, the convention in the international community, or to interpreting the agreement, is that we give as little information as possible to the information holder. And what is provided is to let that person give the information to the authorities. That is the basic concept. When we are implementing the agreement, most countries are following this particular convention. Simply said, this is a convention and not is infringing which agreement. Is that true, Mr. Chu? Well, yes, it's international convention. Now, do you have a document? Can you just point it out? Let's just not talk about and delay this. Yes, we're talking about it on a very deep level already. Is there any particular agreement or article about this? Now, Chairman, perhaps I should say this. Looking at the wording of the blueprint, and it's disclosing the minimum information. This is the wording for use in the OECD. Now, Mr. Chu, and in terms of confidentiality rules, cover the competent authority letters. Sorry, which letters? Competent authority letters. So if you don't disclose the letter and you disclose the name of the country, then you won't be violating this. Well, Chairman, if in that particular case you really have a need, we will consider it. But can you just say, no, I don't need you to do it for every case. I'm just asking for you to be flexible. Just don't think about generalities. Okay, you're saying that you can't disclose it in generally, but can you disclose it if the information holder has a request? And be flexible. Can you do that, Mr. Chu? Chairman, I think in the document's paragraph 9, we set a solution. If the information holder has a request, and if the country who is making the request consents, well, we don't have to talk about it if they have consent. I think we do have to respect our contracting part, the other jurisdiction. Yes, Mr. Sin has asked. Minimum content and confidentiality covers authority letters. In your interpretation, is that disclosure of the country name is violating these two? Mr. Chu, can you answer, please? I have another question. Mr. Chu, can you answer, please? Is that what you're saying? Please state it. Chairman, my answer was that international practice is this. No, Mr. Sin is asking you. Disclosing a country name. You've talked about 2 points. Minimum contact and confidentiality covering authority letter. Is it that disclosing the country name will violate these two sections? Yes or no, please. Please don't go around in circles and talk about the other things. Yes or no, please. Okay. Madam Choi wishes to speak. Yes, I think we all understand. You can understand that in the OECD, it won't talk about such details. But in the agreement, or perhaps in the commentary, one very important aim is that in terms of confidentiality, is that they won't list all of these different scenarios. But the most important overall meaning is that in handling this, is that it will not affect the investigation. Yes, I understand. So are you saying that? Yes or no? Yes, it will affect minimum contact. And yes, it will affect the confidentiality. Can you just say yes or no? I think it's very difficult to say. If you say it's very difficult to say, that means that even you are thinking that in some instance it's not affecting minimum content. Perhaps I'll retire 5 minutes and then you find the answer. If you can't solve this, we have to have a meeting. You have to answer the question. If you're not sure yet, maybe you can go back and think about this. Actually, Chairman, I have another question. Yes. Under the information you have provided, do you know what information is being released by the other countries? You don't even know, do you? Can someone answer this? Chairman, as we understand, we are always looking at the practice of other countries. And as mentioned in the documents, we have a standard template to ask information from the third party. These templates have been looked at by the experts of OECD and have made recommendations. So why do we do this? It is because we hope that HKS, our government, when we are requesting information, is in line with international standards, with the standards of OECD. That is not the question by Mr. Sin. It is that if we ask other countries to request information to third parties, yes, directly. When other countries are asking information that is requested by Hong Kong, they will not tell the third party that the information is from Hong Kong. Yes, I know. I know this. Yes, Mr. Sin, so that they know that the other parties will not be disclosing that the request is coming from Hong Kong in all situations. Yes, this is in general. Yes. Now, Chairman, if some country asks us whether or not they can disclose that the request comes from Hong Kong, that has not happened yet. Okay, I understand.
Ms.
Ms. Kwan, are you going to consider this? If the answer is that not this time, then sorry. I would like to listen to the Secretary or the FS for his response. We have considered the relevant factors. I don't know whether the legal advisor can offer some assistance here. Frankly speaking, this is not really about the 3 orders, not about the contents of the 3 orders. I should say that this is not unique to the 3 orders, but the 3, this is covered. I may object to the other ones. If you say self-incrimination is not going to be protected. All right, let's not waste any more time. I'll issue a letter to the Secretary or the FS saying that we need more information from them. All right? Any AOB item? No. Meeting's adjourned.